All right, I'm here with John Monroe. We just had the Kyle Rittenhouse verdict come in, so I wanted to bring someone on who's knowledgeable in the area of legal self-defense claims. And John is a lawyer who's dealt with these exact kinds of cases in the past. So, John, if you could explain for the audience just a little bit about yourself for anyone who might not know who you are.
Sure. I've been practicing law for about 28 years. Licensed to practice in Wisconsin and in Georgia. I currently live in Georgia, but I still have quite a few cases in Wisconsin. In fact, I have a case at the Wisconsin Supreme Court next month. I'm going to be going up and arguing. I concentrate my practice on gun law litigation, both on the criminal and civil side. So this is the kind of thing that I work on.
Right. And that's exactly why we wanted to have you on. Obviously, we try to do things a little bit differently here at the Reload. We look for, more sober, serious analysis of events. We're not about hot takes. So I wanted to have somebody on who's had direct experience in exactly this kind of case. Rittenhouse has been charged, or was charged in Wisconsin, and he pled that he had a self-defense claim in the case. He now has been ultimately successful. All of the charges against him, he's been found not guilty. One of them was dismissed before going to the jury as well. That was a misdemeanor weapons charge. We can get into the details of all this, but I just wanted to make sure we had someone on who actually knows what they're talking about. I know that's maybe a novel thing in a lot of media outlets. So that's where we try to set ourselves apart a bit. So are you surprised at all by the ruling we just got?
I can't say I'm surprised. It seemed at the outset like it was a decent self-defense case, but you see some video clips on the news and things like that. You don't necessarily get the meat of things. So there could have been more information that that wasn't readily apparent. In fact, I think some video did come out at the trial that hadn't been shown before. But from the outset, it looked like there was a decent self-defense claim.
Yeah, that was my take on it as well from the beginning. There's a lot to be said about the circumstances that led up to these shootings and Rittenhouse being in Kenosha that night. And actually, we'll probably get into that a little bit more. I'm going to talk with David French about this next week. But I think when you look at the actual shootings themselves and the things he's actually directly charged with, it seemed fairly clear from the beginning, given all the video in the case that was publicly available right from the start, that he had a pretty good chance of making a strong self-defense claim. And clearly the jury agreed with that. Now, what in your mind, what are the key elements here to him successfully putting on a self-defense claim in this case? What do you think it was that really, what are the, in Wisconsin specifically, right? Because there's slight variations from state to state. What are the key pieces of information or the key elements to a self-defense claim?
Yeah, in that regard, Wisconsin's not so different from most other states, really. In order to have a self-defense claim, you have to reasonably believe that force is necessary to prevent imminent death or great bodily harm. And the amount of force that you have to use to prevent that death or great bodily harm has to be reasonable. So there are two reasonableness requirements in there. You have to have a reasonable belief, and you have to use a reasonable amount of force.
Right. And I guess ultimately what this case comes down to is whether fear for your life whether Rittenhouse was really reasonably fearing for his life or serious bodily harm, and whether or not the force he used to prevent that or respond to those threats was reasonable. And I guess in both cases, the jury here said yes. Now, another thing is they charged him with a couple of lesser crimes in addition to the murder charges. And one thing I'm actually curious about is if they find he acted in self-defense for the larger charges, the more serious charges, does that just follow down naturally to the lesser charges, or how does that work in Wisconsin?
No, not really. Each of those, you're talking about the 5 felony counts, I think, right? Not the 2 misdemeanor counts that the court dismissed early on.
Yes.
For each of those, would be analyzed on its own because each one of those had a different victim. So you'd have to look at each of those alleged crimes and it stands or falls on its own as far as self-defense is concerned. Like, for example, the first shooting that night of Mr. Rosenbaum, you'd look at that to see whether there was a reasonable belief there, and then whether the amount of force used was reasonable, and then you'd move on down to the other charges. The Rosenbaum shooting is probably the most important one in the case because the theory of the prosecution was, well, these bystanders either saw Mr. Rittenhouse shoot Mr. Rosenbaum or they heard about it, so they were chasing him under the theory that they were going to stop him because he was an active shooter. So if the Rosenbaum shooting was not justified, then it would be reasonable for the bystanders to try to subdue the active shooter. If it was justified, then based on the video and the testimony at the trial, then the bystanders were attacking him. And it'd be hard to come to the conclusion at that point that the shootings weren't justified. You had one guy hit him with a skateboard. You had another guy point a gun at him. It'd be hard to come to a conclusion that using deadly force would not be reasonable in those circumstances if the first shooting was justified.
That's interesting. So because that first shooting, the jury determined that he was justified in using self-defense in that situation, using deadly force, the later shootings are impacted by that as well. Even though, I mean, I'm sure maybe perhaps some of these people who did attack him later on genuinely believed that he was fleeing this, that he had done something terrible. That's interesting that it's still a lot of that hinges on whether that first act, that first shooting was justified or not.
Right.
And so I think one of the key things here in the Rosenbaum incident, the first shooting, is there's some suggestion, right, by the prosecution that the force used was not only was he not reasonably in fear for his life, but the force used was too much because Rosenbaum was not armed, right? And so, can you speak to that a little bit? How that works in the law as far as an armed assailant versus an unarmed assailant?
Sure. I mean, things might have been different if Mr. Rosenbaum had been armed, but the prosecution, I think, probably put too much stock in whether or the fact that he was not armed, because you really have to look at the facts of that specifically applied in this instance. And he wasn't armed, but even one of the other alleged victims, Mr. McGinnis, testified that Mr. Rosenbaum lunged for and tried to grab the barrel of Mr. Rittenhouse's rifle. And it's, I think it's widely understood in circles where people who are routinely armed, such as police, that if someone tries to take your gun, if they're successful, you're going to get shot with it, or at least someone's going to attempt to shoot you with it. So I think it's widely understood that if someone, a non-friendly person, tries to take your gun, that if you don't use deadly force, they will. So the fact that he wasn't armed doesn't really matter when you consider what he was doing is trying to disarm Mr. Rittenhouse.